Good afternoon, everybody. This is Paul Ferrillo. I'm a partner at a major law firm in New York City called Seyfarth Shaw. Um, I can't tell you how honored I am to be on this esteemed panel. This is probably one of the most high-profile panels I've ever done. I usually have a bunch of hackers on, Lewis, but I decided to, go respectable this time. Um, Next slide, please. Legal disclaimer is just we're here to talk about facts and stuff like that. We're not giving legal advice. Next slide, please. We have one of you ever seen a panel with three former SEC executives on it, and it's not SEC Speaks. I've got my partner Greg Markell, Louis Aguilar, former SEC commissioner. Troy, are you there?
Yep, I'm here.
You made it. Hooray. We got Troy Paredes, another former SEC commissioner. Mike Maloney, my good friend of Krispy Kreme years, former SEC chief accountant of the Division of Enforcement. Bob Zukas, my teaching partner, CEO of Digital Directors Network, and Rob Yellen, who I've known for 25 years. Rob is one of the leading executives in the United States for directors and officers liability insurance. Rob and I could share war stories continually about stuff that we've done. But really happy to have you all. Next slide, please. That's me, Paul Ferrillo. You can catch me at pferrillo@seyfarth.com. Next slide, please. Here's our agenda for today. We're going to have an overview. We're going to talk about cryptocurrency. We're going to defer on Robinhood and GameStop to the next panel presentation. But I do want to talk about it for a second. We're going to talk about cybersecurity. We're going to talk about SPACs. We're going to talk about handling a regulatory action or proceeding in the Gensler era. And finally, Rob's going to talk about D&O issues. Next slide, please. And by the way, please feel free to ask questions, during the presentation. I'm going to take a look at the questions, and if we have time, I'm going to make sure we ask them of the commissioners and Mike. Louis and Troy, I'm going to open up the first question to you on the overview. Is what we are seeing in the first few months similar to other chairpersons when they've started the game, or are we seeing something different out of Chair Gensler? What do you think?
Or you want to start?
Sure. Hey, everybody. Look, I think anytime you have a new chair or that will decide where they want to prioritize among all the different things they could choose to do. And so from one chair to the next, you expect to see some change. There are going to be certain things that just persist because it just goes to the heart and soul of what the agency does, and it just has to be focused on. But for a significant part of the agenda, it's going to be a function of the issues of the day. And again, a function of how that particular individual wants to focus the time and effort of himself, herself, as well as the entirety of the commission. What I think, so in some sense, you expect to see change, I guess, is the simple point there. The only thing I would say now, again, without trying to say who's more aggressive or less aggressive or this or that or the other, is to say the following. There's two big things going on right now that are, I think, somewhat unique. One is the change, the degree and pace of technological change. And that's blockchain, but it's more than that. It's artificial intelligence, machine learning, whatever happens to come next. That challenges a lot about how do you think about the federal securities laws? How do you think about our capital markets? How do you think about investor protection, capital formation? fair, orderly, and efficient markets, and what then do those regulatory, those technological changes mean? What ought they to mean for the regulatory environment? Right. This is a unique time in terms of the degree of technological change from that respect. And then secondly, the focus on ESG as well. I know that's not the topic for today, but that's a big change as well from the past. Yes, it's been there previously. In some sense, if you go back to years ago, there are elements of ESG that one could point to. But in terms of the focused attention it's getting now, that's unique. And so with those two developments, in the way they exist today, you're bound to see changes in terms of what the SEC is going to focus on, or other regulatory agencies, and I think that's manifesting itself in terms of the priorities that Chair Gensler has identified.
Willis, what do you think?
No, I mean, I agree with most of that. The saying is, man plans and God laughs. Every new chair that I've worked with, and I actually worked with for them, had ideas of what they wanted to do, and then a market event would occur, a flash crash or something, and there goes the agenda. The market crash, Lehman changes everything. Dodd-Frank changed everything. I think Gary, to some extent, may not have had gamification and meme stocks up front and center until about the same time he got sworn in. They were on the front page news, and so they took his attention. The same thing is perhaps true with PACs, although they were around while he was being vetted. But new things happened that focused on him. And who knows what else will happen that will take his attention. I think that the thing I guess I would say is slightly different. To answer the bullet point, third bullet point about his ambitious agenda, I'm not sure if the reference is to the content, the issues that he's dealing with, or the way that currently rulemakings are becoming a little bit more fast and furious. The last one's easy to deal with. Every chairman wants to make a mark. Obviously, it's an important position, an important agency, and they're really not there just to waste their time. And I think Gary may have a certain incentive to get more done early, because if you recall, when he was confirmed by the Senate, they only confirmed him for the remaining stub period that Jay Clayton had, which basically expired June 5th of 2021. And then he can stay under the legislation for about a year and a half. But in June 3rd, 2023, unless he's reconfirmed, he's gone. And the GOP has indicated that they didn't want him to stay period. They think they'll take over the Senate at next election. Their prognostication may be correct about that. And so I think Gary, from his perspective, has to, fish now. He can't cut the bait. He's got to actually move expeditiously to get some of the things that he thinks he needs to be done. They include things like finishing some of the Dodd-Frank work on security-based swaps, incentive-based compensation, things that have been in the works for a bit, but I think his speeches indicates they're important to him. And then Troy mentioned other things that the increased AI and ML translates into what happens in the gamifications, the meme stocks, the behavior modifications, if you will. And that dovetails into market structure issues, which is also part of his agenda to help modernize the equity markets, treasury markets, and more recently in a speech that he gave, the fixed income markets. So they're all interrelated. I think there's more to come, but I think time is not his ally. And so I think you're going to see a lot in the early stages. I think, he's basically got to propose things, I don't know, maybe May, maybe June, maybe a little later, because of the requirement of the APA, Administrative Procedures Act, to provide notice and comment. So, if the term ambitious means why is so much coming down the pipes right now, I think in part that explains it. If he had 4 years, he may have paced himself differently.
Well, Troy and Elise, I have one final question on this slide. A lot of what Chair Gensler seems to be focused on is protecting the retail investor, protecting the mom and pop on the street investor. You know, in light of the fact, Troy, that you mentioned, you know, that we're in a time of extreme technological change, and we're at, you know, the point of time of complex financial transactions. Am I reading this correctly about his focus on the retail investor, Troy and Louise?
Let me jump in and Troy can clean up after me. I think every chairman I've ever read about, and certainly the ones I've worked with, all talk about retail investors and how important they are to be protected. Now, how they get to it can be different. The amount of prioritization that they give it can be different, but investor protection and retail investor protection in particular are paramount. They basically make the markets work, perhaps even more so these days, in the days of no commissions, in the days of all the new mobile apps that you have to allow you to trade. But even in days of old, you talk about institutional investors, but at the end of the day, it's retail investors that make up their pool. Pension funds that allow more systematic, quarterly or monthly investing watered that down a bit. But to some extent, the young millennials are taking some of that back because they're doing more individually, even with smaller dollars. But they combine to, a dollar here, a dollar there. All of a sudden, you've got $1 billion or more. And so I think that the focus on retail investors is probably more acute now than I think it's been over the last decade or so.
And I would just say that along the lines of what Luis was saying, there is consistent focus across chairs, across time at the SEC on investor protection and retail investor protection as a key aspect of that. So in that sense, that particular focus, as I said, is a consistent theme. I think what that means, to again the point Luis was saying, what that means, how that's carried out, how one prioritizes. There's going to be some variation, as one would expect. And in the case of technology, I think really it's a question, okay, what does that mean? And to just put for a moment a little bit of a finer point on that, without question, protecting investors, retail and otherwise for that matter, from harms, from misconduct, from wrongdoing, from fraud, manipulation, and the like, is front and center. And it needs to be, and it ought to be, and it is. There's another piece of it too, which is also really important, which is making sure that the regulatory environment is conducive to innovation that is going to help those investors. And then how do you strike that appropriate balance? That's the essence of policymaking, and then what those policy decisions translate into in terms of rules, regulations, exams, inspections, and enforcement. But now is a really interesting time for those issues to be as top of mind and front and center at the SEC as they are.
Hey, Paul, Paul, this is Greg. Can I sneak in a sentence here or quickly and I'll get out of your way on this? So I agree. I certainly don't have the hubris to disagree with anything that's just said by either of the panelists who just spoke. But I do think there are a couple of things that are different now. One I think is that we are seeing more in types of investments that are new, that are different, and that are may in fact, many of them which relate back to the fact that technology has advanced so that they are possible. And so I do think there are more things, new things coming out at the beginning of Gensler's reign as head of the SEC than we've seen in some time. But the other, if ever, and the other thing I think, in my view, and I don't hold a candle to the experience of the gentlemen who have just spoken, but to me, there's a little bit of a tone of aggressiveness that I don't remember seeing too often in the past. Occasionally, you'd have an aggressive speech about something from the SEC, but there's a little bit of difference in tone, and so to me, those things are different, and I think are factors in what Mr. Gensler is saying in his frequent speeches these days. Thank you, and sorry for the interruption.
No, that's quite all right. Can we go
And
to-
Paul, just one thing that may be helpful to your audience, because they may not be aware, the SEC is relatively transparent about what it's working on and what it plans to do. There's actually something called the agency rule list that's promulgated every so often. In fact, they just did it in June of this year, which sort of tells you the hit list of things that they're thinking about in the pre-rule stage, such as gamification, the proposed rule stage, and the things that are working on to bring final. So it's not entirely a mystery of what the staff is working on and while the commissioners are talking about. In fact, if you hear any commissioner speech, although they may not reference the proposed rule or the pre-rule, I bet you they're sort of conditioning the market for their views, and you can trace many of them back to this list. So it's not a pick and a poke, as the expression goes. While the list themselves gives you only a 60,000-foot view of what the topic is, and at least it gives you some clarity as to what they're working on. And if you don't see it on the list, doesn't mean they're not working on it, but it likely means they're not working on it.
Thanks, Louis. Let's go to the next slide, please. Troy, I found this testimony on a computer. This was Chair Gensler's testimony before the House of Representatives Committee on Financial Services. Let me just read it to set the stage. Right now, large parts of the field of crypto are sitting astride, not operating within regulatory frameworks that protect investors and consumers, guard against illicit activity, and ensure for financial stability. Next slide, please. Currently, we just don't have enough investor protection in crypto finance, issuance, trading, or lending. Frankly, at this time, it's more like the Wild West or the old world of buyer beware. I don't know if that's the old world or not, that existed before the securities laws were enacted. This asset class is rife with fraud, scams, and abuse in certain applications. We can do better. So, Troy, the question I have for you is, Chair Gensler apparently has a dim view, and I'm using dim in my terms, dim view of cryptocurrency and crypto assets. What do you think accounts, for that, the bad street rep here?
Well, I think I don't want to speak for by any stretch. But in terms of my understanding of what stands behind the concerns he's expressed is that he's concerned, as the quotes you indicated, that digital assets, crypto assets aren't subject to a robust enough set of regulatory requirements. And as a result, coming back to the question you asked in terms of investor protection, I'll broaden it out and think about it in terms of consumer protection as well. But that individuals, that people are going to be harmed as a result of that. Now that gets to the heart of the matter, which is to what extent do current regulatory regimes apply to different types of digital assets, and require what they to require. If you talk to a lot of folks, I mean, their struggle is that they feel there's a lot of regulatory requirements that apply, and the difficulty is figuring out how to comply. Set aside the whether you have to comply, but the how to comply. You think about the federal securities laws, for example, and to the extent a particular digital asset is a security, setting aside Howey and all the rest, at least for the moment. Well, once you're within the scope of the federal securities laws, you have all of the 33 Act, you have all aspects of the 34 Act, you have the Investment Company Act, you have the Investment Advisors Act, you have an entire regulatory regime. And sure, there are debates that persist about whether or not digital assets ought to be treated as securities and under what circumstances. But setting that still to the side, the question then becomes, if a particular digital asset leveraging blockchain technology is within the scope of the federal securities laws, how does one comply? How does one comply given the nature of the technology that may not have been, indeed likely was not within contemplation when those particular rules and regulations were put into place? So from that perspective, it's, I think, not a question of does one want to protect individuals and institutions from fraud and manipulation? Does one want to promote the goals of transparency and integrity in our markets and fair, orderly, and efficient markets? Those are all, seems to me, good, important, legitimate goals. The question is, in light of the technological advances, how do we best do that? And I think that's where there has been a persistent difficulty. It often gets shorthanded in terms of folks referring to, you know, uncertainty, but when you unpack that, it, I think, gets to the question of, all right, how do I comply? I'm trying to do the right thing. How do I comply? I think a lot of folks think that more guidance would be helpful, and that it's not the Wild West, at least in a lot of respects, not the Wild West, but some guidance would be helpful to help bolster and promote compliance. I think that's the view of many folks, and I think that continues to be a practical struggle that folks are continuing to work their way through.
Thank you, Troy. Next slide. Troy, I don't know if you saw this, but Commissioner Crenshaw issued a statement this morning, and I took this paragraph. She issued a statement. It was on the more broader topic of decentralized finance. She wrote, according decentralized finance participants' current buyer beware approach is not an adequate foundation on which to build reimagined financial markets. Without a common set of conduct expectations and a functional system to enforce these principles, markets tend toward corruption marked by fraud, self-dealing, cartel-like activity, and information asymmetries. Over time, this reduces investor confidence and investor participation. Commissioner Crenshaw went on to talk about how if you're going to have an offering, come in and speak with them. Troy, so I have a question for you. What is the Commission's view today on whether Bitcoin and other cryptocurrencies should be regulated as securities? Good idea, bad idea? Commissioner Crenshaw thinks it's a good idea. What about you?
Look, I mean, I think the broad question, and I think this is part of the challenge of talking about, you know, digital assets or cryptocurrencies as if they're all the same is part of the, I'll use a word I'm probably overusing, part of the challenge, and that is to say they're not all the same. They do different things. They have different attributes. They have different economics. They have different governance rights. They serve different purposes. Use consumption is more prevalent, less prevalent. Profit motive is more prevalent, less prevalent. The things that drive change in value differ. That's just a few of the differences across different kinds of digital assets. And so from my vantage point, saying all this or all that overlooks what are those important nuances and differences. Now, having said that, when you get to, and I've not had the occasion to read what Commissioner Crenshaw wrote, but it's on the short list of things to get to today, is as I take what you, Paul, had just read, that the question then, and this is a way to think about the debates around Howey. One way to think about the debates around Howey is about, from a more technical vantage point in terms of what that line of jurisprudence means or doesn't mean as applied to particular facts and circumstances. Another way of thinking about it is the jurisdictional threshold question as to whether or not the SEC has a role to play as to certain kinds of assets. And so you can see why there is so much attention on that question from a regulatory perspective and from others' perspective, because if it's not a security, well, then it doesn't fall within the scope of federal securities laws. And if it is, then it does. And to the extent one thinks that the SEC has important interests at play that promote, in one instance, investor protection, capital formation, fairly efficient markets, but as Commissioner Crenshaw put it, if I understand the quote correctly, that regulatory regime is important for the space to be successful over time. Well,
Yes.
From that vantage point, you can see the argument for saying something is a security to bring it within the scope of that regulatory regime. So without coming down one way or the other on the overall kind of categorization, one-size-fits-all approach, but just to rather offer the perspective of why that question of is it a security is so important. It's because it's jurisdictional and so fundamental and threshold in that way. And if I just had 20 more seconds to make this final quick point, which is there is so much attention on the SEC. I do think it's important not to lose sight of the fact that there are a lot of other regulators as well, both at the federal level and the state level. And even if something is not a security, it doesn't mean that there aren't important and effective regulators, forceful regulators at the federal level and the state level. And that I think is important to be mindful of as well, that the SEC is a part of the regulatory landscape, a really important part, but it's not the entirety of the regulatory landscape that's at play.
Thanks, Troy. One final question before we turn it over to Luis in cybersecurity. This is a related cybersecurity question. It came up, as you may know, in recent indictments, Troy, of the Principles of ReEvil, a big hacking outfit out of Eastern Europe. We hear a lot about ransomware in the corporate sector. I can't find the reference, but has the SEC taken a position on whether Bitcoin and others have unnecessarily and harmfully increased ransomware attacks? Have you seen, that expression, of interest from the SEC?
I'll be very brief on this, knowing that we're going to hear more from some experts in a second here. But the one thing that folks may want to take a look at, I believe it was the summer of 2020, the Division of Exams put out an alert that walks through a bunch of guidance and perspectives on ransomware
Resiliency
and related issues. Yeah, and so that alert is worth folks consulting to seeing what the Division of Exams put out on this very topic.
All right. Thanks, Troy. Next slide, please. Cybersecurity. Luis and Bob, I've been in this industry in the cyber, side of things since 2012. Can you spell Target? Can you spell Michael Stores? I have always challenged classes and people that we're speaking with. I think 2017 and 2018 were sort of a watermark that brought cybersecurity to the forefront of the SEC's watchful eyes. Luis, do you agree with me?
I do think things occurred at that time. But, sometimes because of so much activity in the recent years, people lose sight of the fact that the SEC has actually thought about cybersecurity issues for a long time. And it may be helpful to put that in perspective. The SEC over time has had very quiet periods where they don't utter the word cybersecurity, perhaps periods where they didn't really fully know what it meant, and then periods of more intense focus. But to be clear, the SEC has focused on concerns for a number of years. Although admittedly, not in the area of publicly traded companies where it's gotten the most press, certainly when after Target got hacked and thereafter. But you go back to 2000, the SEC adopted regulation SP, known as the safeguard rules, that applies to broker dealers, investment advisors, mutual funds, that basically require them to have written policies and procedures to safeguard and protect their customer records, including from cyber attacks. In 2013, they did Regulation SID, the identity theft red flags rules, requiring many of the regulated entities to address risk of identity theft, including from cyber intrusions. And then in 2014, there's just some taking you to a Cook's tour through some of them. The SEC adopted Regulation SCI, Systems Compliance and Integrity, specifically to strengthen securities exchanges and other trading markets. In fact, just 10 days ago, SEC Commissioner Roisman referred to Reg SCI as the Commission's most extensive policymaking in cybersecurity, and that was in 2014. So they've had a history of this. But to be clear, in that process, they haven't really focused on publicly traded companies. They've not yet, to this day, issued any rules explicitly imposing specific cybersecurity regulated obligations on public companies. What the SEC has done, and we can talk about that in some recent cases that they've done, what the SEC has done is to rely on other existing regulations. Many of them drafted without any thought to cybersecurity. That's just not why they were drafted. And they've taken those rules and chose to provide guidance as to how cybersecurity issues can fall under those existing regulations. Their first effort was in October of 2011, a SEC staff set of guidance that sort of generally walked through how the SEC's disclosure obligations could apply to cyber risk and cyber incidents. But I think it's safe to say, without slurring anybody, that the SEC has noticed that the 2011 guidance did not really result in significantly better disclosures about cybersecurity matters, perhaps an understatement. And so they're looking at the cyber incidents, they're dominating the news, they're comparing it to disclosures they're getting, and they're seeing a major disconnect. So they did turn their attention, and it was prompted by a couple of things, but did turn their attention to a more robust, expansive set of guidance in the February 2018 guidance on cybersecurity disclosures. And there was two important things there. One was that this was the commission speaking, no longer the staff. This is the commission telling you, this is the way we're going to think about it when enforcement cases show up on our desk, and when we're thinking about rulemaking. These are the kind of things that we really think. So it's not just the staff, it's the commission. And while commissioners can change their minds from day to day and week to week, and new issues and new facts require different thinking, it's important to note that this was actually the commission speaking. Now, it's not entirely surprising that the SEC thought greater clarity was needed, given all the headlines and all the cyber-related incidents that affected public companies. But I think if you have to point to a couple of events in 2017 and 2018 that perhaps were the catalyst to the SEC finally doing a more expansive guidance, probably was the Equifax breach of 2017, maybe the Yahoo breach, but the Equifax breach that was discovered in July 2017, but not made public until September of that year. And that dominated, if you recall, that dominated news, for a bit, not only the trade rags, but turn on your CBS, ABC, or NBC news, and they're talking about it. And then the other shoe that dropped was that the SEC's own experience with its own cybersecurity threat when they realized that they've been hacked. When their Edgar system was hacked in 2016, they didn't realize it for a bit and only disclosed it in September 2017. I think those two events were probably the straws that broke the camel's back and got the SEC's undivided attention. In fact, only days after the SEC's disclosure about it being hacked, the SEC announced that it was going to establish an enforcement cyber unit to focus on targeting cyber-related misconduct. All of a sudden, it became really real. And I suspect that about the same time, someone immediately started to draft the 2018 cybersecurity guidance. So I'd have to say that it's fair to say that since then, the SEC has had a laser focus on things that are cyber-related. But those two things in 2017, 2018, I think probably were their wake-up call. But I must tell you that I tend to think they would have done it anyway, because more events were occurring in the market. Hacks were occurring of companies, of governments, of individuals, of hospitals, you name it, they were being hacked. And I think the SEC would have gotten to it eventually, but I think Equifax and their own hack probably were prime suspects in them getting off the dime. Bob, I don't know what thoughts you may have about that.
Yeah,
I'm going to ask, Bob, I'm going to ask you a question related to the 2018 guidance. It's a question that we speak about a lot. If you read through the lines of some of the SEC recent guidance and recent speeches, what's coming out is that cybersecurity is a systemic issue. What do you think about that? Is the SEC finally realizing, after things like SolarWinds and other, that one hack can affect 1,000 companies?
yeah, I think that's another kind of wake up call, certainly on these issues, and it really goes to the issue of how do you regulate and how do you even govern and manage distributed risk? And so we live in a complex world where there's distributed risk everywhere now, and certainly through the digital business system. This is a level of complex business systems risks that we haven't ever had to deal with before. So yes, I think we are starting to see systemic risk and cyber risk and how they interact and how they create this entirely new risk environment, cause the SEC and other regulators, including New York DFS, who came out with their cyber guidance framework that specifically addressed cyber risk, start to consider what could really go wrong and how bad could it get. Now, when we talk about systemic risk, people think back to the financial crisis of 2008, too big to fail. That's what that was about, right? And I also like to remind people that it was less than 20 years ago when it was a novel concept to have somebody on corporate boards that understood a financial statement. And it took the existential threat of a capital markets meltdown, that a failure of confidence in the financial reporting process and system could potentially have delivered, to force the SEC to bring a sledgehammer to that issue and force qualified financial expertise disclosure, force financial literacy onto corporate boards, put that structure in place, the committee structure that we see today that we're very, very familiar with. And so I don't think we contemplate the levels of exposure and risk yet systemically. We're clearly living through COVID, which is very systemic. But I think there's an awareness that this is a problem, but we still don't yet understand the scope of systemic risk. And so we don't see yet the sledgehammer coming out, but we are seeing regulators and policy leaders start to pay attention to that issue.
Yeah, and I think that's clear. What to do with it, as Bob says, remains to be seen. There's systemic risk that can emanate from a single hack. Colonial Pipeline, for example, shut down gas production, certainly throughout a large swath of the country. Then there are these coordinated attacks. Recently, I think the DOJ brought an action against 2 or 3 people that did ransomware in 1,000 companies pretty much at the same time. Kind of
Yeah.
Yeah, and there's SolarWinds, which affected so many people because so many people used it. And those are different types of systemic risk, and how you address them may be different from place to place. I think Biden's now requiring that any federal contractor notify them of any risk so they can get a better grasp on that. And so people are thinking about it, but until you get a handle really on the various ways you can have a systemic risk event, it's going to be, and maybe you have to think of all the multiple ways you can have it and try to address all of them. And my guess is the SEC won't be enough to deal with it. For example, you mentioned ransomware at the end of your conversation with Troy, and whether or not cryptocurrencies, particularly Bitcoin, facilitate them. Of course, the answer is clearly yes. Every ransomware attack tells you pay us in Bitcoin. And so much so that other agencies like OFAC, Department of Treasury's Office of Financial Assets Control, 2 months ago did a whole slew on how anyone who pays a ransomware attack using Bitcoin and uses certain sanctioned entities, they in turn are going to be sanctioned. So you got a whole slew of players coming into this for a lot of reasons, but I think systemic risk is the one that at the government level really frightens people.
So, well, listen, Bob, I have another question for you before we turn to, well, actually, it came up in First American Title. one of the bigger issues that, keeps showing up, it showed up in Yahoo, as you may remember, the whole concept of cyber breach notification. You've had companies sometimes waiting weeks or months to report a cyber breach. It came up in First American Title. Luis, do you think we're going to continue, based upon the focus on the investor, do you think we're going to see, in fact, maybe in the fall guidance that the SEC has said it's going to issue, do you think we're going to see something more mandatory or strict around breach disclosure and the time it must take place in?
I think that's probably in the offing. I would tell you that it's anybody's guess, so this is really pure guesswork. I mentioned Commissioner Roseman just a week ago said that he knew they were working on it, but he had no idea what they were working on, so he couldn't comment on what was going to land on his desk. And I think Troy and I can speak from experience about rulemakings that we thought we knew where they were going because our staff was talking to the staff writing it. And then the rulemaking hits the chairman's office, and by the time it comes out of there, it's slightly less recognizable. So a lot remains to be seen about what they'll do. But it seems to me that is certainly on their to-do list. Although First American does show that existing laws can be used to enforce cybersecurity disclosure by making sure that other rules, such as the rules that require people to have policies and procedures to funnel the disclosures throughout the organization to the people who are making the decisions as to whether or not to publicly disclose, and that they expect that to happen quickly, because that was just really a matter of months. And so I think they may think that perhaps the bully pulpit or perhaps the enforcement action against First America may suffice. But I suspect that they may want a rule that puts some specific time frame on it, properly qualified, I would hope, because you don't always know what you know until you know it. And cybersecurity is one of those things that you begin to suspect, but sometimes you got to bring in a forensic auditor, forensic cyber expert to come in and really look and see exactly what happened and why it happened. And you may not want to disclose something until you actually know what it is you're disclosing, because the panic could ensue and make things a lot worse. And so I think it may be hard for them to put a specific time frame around it. Perhaps they could do disclose to the SEC, but not to the public. That can work on occasion. But yeah, as I said, I'll end with where I started. It remains to be seen, and I guess I'll wait till the rulemaking lands in the public eye and read it to get a better feel for what they have in mind.
Paul, could I make a quick comment?
Sure.
Yeah, I'll be very brief. And everything that Luis and Bob said is right on, and particularly Luis talking about the 2018 guidance and how it kind of generally looks at other parts of the securities laws. I was chief accountant in enforcement when the Yahoo case was brought, and I've actually more recently served as an expert in a private litigation around cybersecurity disclosures and the application of those rules. And what I think is going to be interesting is I especially with a tone of aggressiveness in enforcement, to see if there is a migration going forward here where, the Yahoo case, I think, stood, as you said, for a pretty simple proposition about disclosing notice, and it took a long time to get that notice out there. Whereas if we will see cases, which I suspect we may, that are going to be more particular in the disclosure area, nitpick, whether it's in MD&A or risk factors or otherwise, and the guidance covers all of that. And obviously, as the slide says, materiality is a very important consideration, whether we will see a migration where, good faith disclosures are being questioned more specifically rather than these broader issues, such as there was no notice at all that a breach had occurred. And I suspect we may see those kind of more specific enforcement cases coming.
Yeah, and just to add to what Michael says, so sorry for dominating, but I have given this some little bit of thought. The SEC's disclosures really focus around quantifications, dollar amounts. The Pearson case, which actually I learned about by reading something, Paul, that you and Bob wrote. The Pearson case is really an attempt to say no. Materiality can be viewed as differently, qualitatively, if you like, based on your operations and what's important to you and your shareholders and your company. And so I could see perhaps an attempt to try to codify that kind of definition of materiality. I suspect it's you don't want it to be like Swiss cheese and you don't want it to be like a bunch of landmines. But I suspect somebody's making an attempt to do that so there can be more guidance other than just it's in the eye of the beholder, although perhaps in the eye of the beholder is probably the best way to handle very fact-intensive, company specific and industry specific issues. But I could see that perhaps being thought about.
I'm gonna skip First American Title and go to Mike Maloney now. Can we switch next slide, please? Another big issue that we have seen all year is the whole area of SPACs, or special purpose acquisition company. Mike, tell us what you're seeing from the SEC. You know, what do you think accounts for the boom in SPAC transactions over the past 2 years?
Yeah, well, I'll start by saying what's on the slide and just to orient very quickly what a SPAC is. And it's also referred to as a blank check company that raises capital through an IPO with the intention to use those proceeds to acquire a company at a later time. They don't have commercial operations at the time of the IPO, and they've been around for a long time. But in 2020, there was, and since, there's definitely been a spike. And, you know, they do represent a very attractive way to, fast, certain route to liquidity without a lot of delays and market risk and the like through the traditional IPO process. And so what explains the burst? There's been a lot of commentators out there that have talked about it, but I think if I had to sum it up, I would say that, with it being a very efficient mechanism to access the public markets, in a period when IPO activity generally was very hot. And now this is just me making a quick observation. I actually heard an interesting comment during the COVID period where, there was a point of view that, CEOs and investment bankers and board members had a little bit more time on their hands than they might otherwise have had in a normal period where they were traveling around the world visiting their operations and sitting behind the screen, kind of having a lot of time to think strategically, and being one factor that leads to more acquisition activity, more IPO activity. And so there's an interesting timeline in terms of your question about the burst in activity that I'll just hit very quickly. In 2020, there was a huge increase in IPO and SPAC activity. Just some statistics quickly, global IPO activity reached more than 300 billion in 2020, a 60% increase. And there was a significant similar increase just in the US. SPAC IPOs accounted for 50% of the total IPO capital raised in 2020, according to some data from Goldman Sachs. And then that continued in the first quarter of 2021, where SPACs really continued to drive of the 389 IPOs raising 125 billion in the first half of 2021. In the first 3 months, 298 were related to SPACs. So that was kind of takes you through the second quarter. And so a lot going on with COVID and just a lot of IPO activity. But then in part due likely to some guidance that was issued by the SEC in April of 2021, there was a bit of a pause, and there was in the second quarter ultimately a pretty big slowdown in SPAC activity. That guidance had to do with a very highly technical accounting issue in terms of warrants that are issued in the SPAC transaction and how those are accounted for. Kind of view it as a pause button where companies, their accountants and their auditors had to look at restatement issues around this issue, and it, I think, kind of spooked the activity level in that quarter. And just as one data point, in one company who tracks this says that by July of 2021, so within the first couple of months after that guidance, there were 340 restatements related to SPAC issuers, which is a tremendous number of restatements, highly technical restatements, but a restatement nonetheless. So that just gives you a sense for how that guidance affected the market. But just to finish the answer, in the third quarter, and as we get towards the end of the year, we're kind of seeing the bounce back. And I think, some commentators have said that's because, that issue of the restatements has been kind of sorted through, and now that issue is getting dealt with in real time. And so there's been kind of a bounce back in the SPAC activity. And then as we get towards year end, with companies wanting to get these transactions done, I think we'll probably continue to see a rebound. So I'll pause there on the burst in activity issue.
So let's go to the next slide, please. So Mike, we're gonna go a little bit quicker here.
Yep.
Move through some of this. We've seen SEC staff asked by Chair Gensler to review SPAC process focus on investor protection. We've seen several of these developments. The one I wanted to ask you most, coming from the Division of Enforcement, tell us about, there's been some high-profile cases in the last couple of months. What have you seen out of SEC enforcement on SPACs?
Yeah, I think you're going to continue to see more activity out of SEC enforcement. I was just participating in an event last week where a senior SEC official in the division talked about, some of the concerns that she and the division have, and it's very fresh. And, she mentioned things like this. I know Luis and Troy will remember, and we're a part of the Chinese reverse merger initiative that occurred over 10 years ago and related to reverse mergers, which have many similar attributes to these kind of cases. A focus on disclosure issues and a focus on internal control issues. And if I had to summarize, those are the two big areas related to SPACs that I think enforcement will definitely be focused on. The Stable Roads case, which is on the slide there, which came out in July, this case is interesting because of all of the parties that got charged by enforcement. The SPAC, its sponsor, the CEO, the SPAC's proposed merger target, and the founder and CEO of the merger target, all were charged. And in fact, the SEC official last week talked about this case, saying it was important to enforcement to send a message that all participants in these types of transactions are going to attract scrutiny if that's warranted. There were misleading claims in that case about the technology of that company, and also allegations of misleading, not disclosing some national security risks related to the individual that founded the target company. The remedies were very broad, including scienter-based fraud charges against the target, and negligence-based fraud against the SPAC, and then a whole range of penalties. And so that case, I think, stands for a wide viewpoint from the SEC to look at all participants in a SPAC. The Akazu case, which just came out a few weeks ago, and I hope I said that right, I probably didn't, very quickly, is a different kind of case where, and this kind of reminded me, because there were some of the Chinese reverse merger cases when I was chief accountant, reminds me more of those situations where the underlying company, the target company, was alleged to be a rapidly growing company. It was in the music streaming space. And the allegations are that even though they had disclosed that they had something like over $120 million in revenues, the revenues were negligible to non-existent. And so underneath, having a company that really just isn't a company, that's obviously, whether it's a SPAC or not, going to be a kind of case that would attract enforcement. But I think the last thing I'll say is that because, and I think we saw this again with the Chinese reverse mergers, a lot of the target companies, quite frankly, one of the questions for people to ask is that company ready for prime time in terms of being a public company from a disclosure standpoint, and particularly an internal control standpoint? And I think you saw that a lot in those other cases, and I think you'll see that in enforcement cases here going forward, that these companies are being rushed to market in some cases, and a lot, from my own current experience working on some matters, there's a lot of scrambling going on to get the internal controls up to snuff to be able to handle being a public company.
Thanks, Mike. Really appreciate it. Greg, we're going to turn over to you now. My partner, Greg Markell, has done SEC investigations for most of his career. We talked about that yesterday. I might have done bigger ones than he has. Ha ha. But Greg, you've heard a lot about the Chair Gensler's administration. What do you think of? How do you think SEC investigations are going to be handled? You know, given all the activity that you have seen and heard about over the last 45 minutes. Next slide, please. Greg, you're on mute.
I have to buy drinks as a result of that. But in any case, this is not my slide, the one you have up. So can we move to the next one?
Oh, the next slide. Sorry.
Yes. Okay. So here's what I am going to do, because I want to make sure that there's plenty of time for others to speak, and I'm going to move through it quickly. I am going to cover things on these slides, but I'm not going to cover every line. I think it's the wrong question, Paul, frankly. I don't think that the way an investigation is done, I haven't seen any evidence that the SEC is going to change how it does an investigation. I think what we've heard so far today is that there are more areas where there will be investigations, which is different from how you do an investigation. And I do think there are more areas. We'll see more investigations. I'm not so sure that there will be a very great difference, although, and I thought Mike had a lot of very interesting information, and when he was talking about the accounting cases, one thing they will do in some of the investigations where there are these technical accounting issues relating to SPACs, that will be a little different, because they're going to have to make sure that attached to every team doing an investigation is someone who is very familiar with a very, very technical accounting issue on SPACs. It's not a simple accounting issue. It's very technical, and it's controversial. So that's the only thing I know of that changes a way of doing an investigation, although that may evolve as we go forward. As I indicate here, the first question is, what causes the SEC to commence an investigation? Well, first of all, I'm a securities litigator who does a lot of investigation work, and have spent probably the biggest matter I've had for the last 4 or 5 years has been involving an investigation. But nonetheless, I also think of myself as both as a securities litigator and an investigator. If you're involved in a securities litigation, it is often no surprise that the SEC knocks on your door relatively soon. That is a reality when you see certain fact patterns in a litigation, and the litigation is public. But there are a number of ways that investigations can get started. One of them being that there are civil or criminal claims being brought by others that raise an issue for the SEC. But there are a number of other ways they can do it. I mean, for example, the staff receives information just as the rest of us do from public and non-public sources. One assumes that they see articles on SPACs and Robinhood and GameStop stock and et cetera, which may cause them to think about and pursue a little bit more the kinds of issues that might come up in those situations. The enforcement division may get referrals from other SEC divisions, such as accounting or examinations, where regular reviews of accounting practices are done in those other divisions, and they can get referrals from those divisions of issues that should be looked into. You can get customer complaints, you can get whistleblower complaints. And other federal agencies can also suggest ways and suggest issues that should be looked into. So there are lots of ways that these things can start, but I don't think it's very different how they're going to be handled. The next page, and please, next slide. This is, I think, important for people to understand if you haven't been involved in SEC investigations yourself, the informal versus formal investigations. And it's important not only because you need to know how to deal with each, but it's also important because a lot of the ability of the SEC to get information derives from this dichotomy. So an informal investigation, despite its name, is a very serious matter. Usually it comes about as a result of getting a phone call or a contact. Depending on the situation, it may go to your client, it's him or herself. It may go to a lawyer if a lawyer has already appeared for that party. But there's a contact, and it usually involves a request for information, either for documents or for interviews. The interviews are very much like depositions. In some ways, where they're worse than a deposition in a civil case, because often you'll have 4, 5, 6 people from the SEC or the FBI or other agencies in the room questioning a representative of your client. And it can be a little bit intimidating and daunting whether the person has done anything wrong or not to face that. But that would be typical. These are not pursuant to a subpoena. You're not required to respond. But if you don't respond, if you are a reasonable candidate to be looked into in connection with a given fact situation, it will not reflect well on you in my experience, in the eyes of the enforcement staff, who are the people leading the charge, to refuse to cooperate. So the reality is, and their remedies are several, but one is to convert a informal investigation to a formal one, and you will get subpoenas. So, in the end, the difference between the two, at least in the early stages, is not very different. But you are expected to cooperate and give information, give documents, and you may get some information back from the staff as to what they're interested in. And certainly in an interview, that's one of the things you're primarily looking for, is information about where the SEC is going and what they're interested in by their questions. But it's a pretty one-sided procedure, in my view. Next slide. Like any other litigation or investigation, the job of the lawyer is to get as much information as they can, immerse themselves in whatever factual information is available, try and understand, in this case, where the SEC is coming from, and what their concerns are, and typically the SEC is not going to say you're a target or not a target. They're going to say we don't do that here. And so you don't you typically don't know whether your client, in some situations at least, you don't know whether your client is a target or isn't a target. And so you absorb as much factual information as you can get from any source you can find. So you're on top of everything that's available to you to make some judgments. And importantly, you start developing a strategy for how you're going to move forward with this, and what you think where you think the risks are, where you think the problems in your client's position might be. You do legal research as necessary. Let's go on to the next slide. But you are trying to become a sponge to factual information. You also, I think, and there are different people have different styles. My style is to fully cooperate with the SEC, at least at the beginning, until you understand better where they're going. You try to cooperate as much as you can, because you want them to understand that you're a straight shooter, that you have credibility, that what you say you will do, you do, and that they can work with you. You're pleasant on the phone. You're not harsh. You're not haranguing them. Those are things that I think are vitally important in an SEC investigation, and in lots of investigations, but it's particularly in an SEC investigation. You want to be able to talk to them. You want them to talk to you at least a little bit. It's usually not equal. You usually have to give a lot more information that you get, but you should be trying to get information from them of where they're headed and where your client fits into that scheme. And so my experience is that when you get later on in the process, if you're still in an informal investigation, it changes a bit. If you've moved to a formal investigation, but in an informal investigation, my experience is if you demonstrate that you're a straight shooter, that you are going to do what you said, that you are not hostile, you're trying to work your way through this, you often can get some information from the SEC about where they're headed. And when you get to a negotiation about whether, if you do, maybe the SEC will just drop it, and as a result of the discovery that they do. But more often, you're dealing with whether or not your client is going to make some sort of offer of settlement. The SEC at that point is going to be holding all the cards. But if you've developed a relationship with them, and as I say in bullet point 1 on the current page, remember, in life and in the law, relationships matter. If you've developed a decent relationship with the enforcement staff, it's going to help you try and work through and negotiate the deal that might resolve the issue for your client. Now, it's going to vary a lot depending on where your client fits in the overall theory of the SEC's case. There are some people they're not going to negotiate with. One of the things, and let me go to the next slide, please. Remember, the SEC is holding all the cards, and so when you're negotiating a deal, you're trying to bring some sympathy for the position of your client to the SEC. There are reasons in trying to persuade them that there are reasons why they should either drop the case or go lightly with your client. And I think that is largely the way I approach these investigations. Now, there are other things, though, to keep in mind here. And one of them is And Rob is going to get into this question, I believe, in his next section, which is next on the agenda. But one of the things that is a little bit disturbing to me is that there's now talk at the U.S. Attorney and at the Justice Department about the Yates memo and going after higher level people. And I think there's some question as to whether or not the SEC will also follow to some extent that approach. And that is very troubling about when you get to the role of directors. But I'm going to leave that to Rob. And I think I'm turning over to the mantle to Rob at this point for his section.
Can you go to the next slide, please? Next slide. Next slide. There you go, Rob. Rob, you're on mute.
So that means I'm buying drinks after Greg buys drinks. Let's go to the next slide as well. So one of the things I want to do is, first of all, promise everybody we committed we were going to be done at 2:15. We are going to be done at 2:15. So that you're getting that commitment from me now. Two things I want everybody to take away from this session. We've had great speakers talking about things both at a very high level and then a bit deeper in the weeds. But the reality is, I've heard the word more aggressive or aggressive tone. I've heard about things we don't know about. We're not sure where it's going to go. Uncertainty and enforcement vigor are things that are concerning for the D&O space. We're already in a market space that is coming out of 3 years of a very hard market. It's a little less hard now. So at Willis Towers Watson, we're projecting that rates for next year, depending on the posture of the insured and the risk profile, will be at the primary layers for D&O somewhere between flat to up 25%. So you're still seeing a lot of upward pressure at excess layers, a little bit less at flat to plus 25%. And then for side A, it really becomes an issue of looking at things on a case-by-case basis. You see a lot of the same themes we talked about today: IPO, SPACs, capital formation, regulatory uncertainty, cyber and privacy, event-driven claims, where I wanted to go, but I'm not sure if we'll have a chance to get there. And then systemic exposures. You heard a lot about systemic exposure. Some of the things that are just a little bit different about this SEC, and I don't know if it's a change, as we look at our culture and what is important to investors, ESG is often talked about, but we see that investors are paying attention not just to the same old financial information, but they're looking at more. They expect better behavior from directors and officers. They're looking for board diversity. They're looking for companies that really appreciate environmental, sticks to promises on emissions disclosures. And as we look at how in recent years in the civil world, the plaintiffs' bar has glommed onto this, and there's been a trend we call event-based securities claims, which are claims that big events trigger an opportunity for the plaintiffs' bar to allege that something people may have known about, but might not have known about, but it was big enough and there should have been either controls or there should have been disclosures. As we've seen, that drives securities claims up very recently up, and then this year so far, not so far up, but we expect them to get big again. But what we've seen this year also is that the SEC seems to have taken that up with some of its enforcement. We saw, for example, in September, the New York Times reported that the SEC was investigating a well-known video gaming company for disclosures around its frat boy culture. And it shows that this is going to go into more than just financial accounting, but that they're actually looking at some of these social issues. Maybe that's telling all of us that materiality is evolving as our expectations for how investors are going to behave is evolving too, and it's something that bears watching. The other thing is, when you're involved in an investigation situation, it's really important to understand that your D&O policy probably is designed to do some things, but you're going to have gaps in coverage. Off-the-shelf policies are not going to be an ideal solution. With enforcement risk ramping up, definitely take time, talk to your insurance professionals, and get a solid read on where your policy is versus what you might be able to get in the market. And with that, I'll pass the torch back to Paul.
Thanks, Rob. You have been, one of the best and finest advocates of a solid, insurance market in the past 25 years. We've done everything together that I can remember that's been bad and ugly or worse. And I want to thank you and Willis Towers Watson, for co-sponsoring our event today. I think Lewis and Troy and Greg and Mike and Bob, we've blown everyone away. We don't appear to have any questions, from the audience. They must be sitting back saying, wow, like I am. Did I just listen to this panel? I think that all the speakers did a fantastic job. If you have any questions, next slide, please. Please reach out to to me at pferrillo@seyfarth.com, Greg Markel, gmarkel@seyfarth.com. We can pass those questions along to the panelists. Troy and Luis, I want to thank you so much for being part of my panel. You guys did a terrific job, and thank everyone else. Really appreciate it. And Rob Yellen, we ended at 2:16, which isn't terrible. Thank you very much, guys. We'll end it here. Thank you all.
Have a great day.